The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain appeals to the Illinois Supreme Court. So let's start by talking about Illinois court structure. Most cases are first heard at the circuit court level, so every county has a circuit court, and this is where full trials are conducted and most cases are heard and a final order in the case is entered. If one of the parties loses at that level, either party has the right to appeal to the appellate court, and there's several different appellate districts in Illinois, each consisting of multiple circuit courts. So whichever circuit court you're appealing from, you have to go to a particular appellate district and file an appeal to the appellate court. If you lose at the appellate court, you don't have the right to appeal to the Supreme Court, but what you can do is file something called a petition for leave to appeal, and you can ask the Supreme Court of Illinois to hear your case. Now, I want to be clear. People talk about the Supreme Court all the time. We're not talking about Justice Kennedy here. This is the Illinois Supreme Court and the Illinois Appellate Court, not the federal court system. The federal court system's set up in a very similar way, but it's a totally different set of courts. So this is the Illinois Supreme Court that you're requesting leave to appeal to. And if you lose at the appellate level, you've got a couple different options. One is that you can file a petition for rehearing with the appellate court. So you're going back to the court that already ruled against you and asking them to hear your case one more time. The other option is to file this petition for leave to appeal with the Supreme Court. These options are not mutually exclusive. You can do both at the same time, or you can first file the petition for rehearing with the appellate court, and then if you lose on that, then subsequently file your petition for leave to appeal with the Supreme Court. So let's talk about when the appellate court will grant the petition for rehearing. So again, this is not the appeal to the Supreme Court, but when the appellate court is actually likely to grant your petition for rehearing of the case you've already lost in that court. This happens usually in one of three situations. One is if you can show that the appellate court has misunderstood a material fact or misapplied the law, or that the law has changed at some point in the process. So unless one of those three things is true, the appellate court is not likely to rehear your case, and it's a very small percentage of cases that are actually reheard. The deadline to file a petition for rehearing is 21 days from the order that you're asking them to rehear. The deadline to file a petition for leave to appeal with the Supreme Court is it can be 35 days from the appellate court order that you're trying to appeal, or if you have filed a petition for rehearing, it can be 35 days from the denial of the petition for rehearing. So let's talk now about when a Supreme Court will actually grant your petition for leave to appeal to the Supreme Court. So we've already talked about when the appellate court will rehear your motion for rehearing. Now we're talking on the higher level when the Supreme Court will actually grant your petition for leave to appeal. There's basically two situations in which these petitions are granted. One is if the appellate decision that you're appealing is in conflict with another appellate district. So remember, I told you that there's multiple different appellate courts within Illinois. They might be hearing cases that deal with the same issue, and sometimes different courts can rule opposite ways on the same issue, and that's called the conflict. So if there's a conflict between the different appellate divisions, then that's ripe for the Supreme Court to decide between two conflicting divisions, and then now that's the law of the land, and even the appellate decision that the Supreme Court rules against, even in that district, they'll have to follow the Supreme Court opinion because that supersedes appellate court cases. So that's one situation in which you're likely to have your case heard by the Supreme Court. The other is if it's a matter of general importance, and this means that it's got a broad implication for other cases, not a very specific set of facts, but a general broad application to other cases. And this usually occurs when it's a matter of interpreting a statute or changing legal trends, or if it's a newsworthy issue or an issue of first impression, meaning that no court has decided this issue before, or at least the Supreme Court hasn't. So let's talk now about what happens if your petition for leave to appeal is granted. Let's say you have an issue of first impression or of general importance, or you have a conflict and the Supreme Court grants your petition for leave to appeal. Well, then what happens next is pretty simple. Each side has the right to file a brief. And a brief is basically a longer form explanation of why you think your appeal should be granted, or why, if you're the other side, why you don't think the appeal should be granted. The petition lays this out to some extent, but a brief is basically a legal argument explaining why you're right, and it's a more lengthy legal argument. So once each side has filed the brief, if they're going to, the Illinois Supreme Court will either just rule on the briefs and issue a ruling without any further oral argument, or if the court decides, the court can request that the parties come and present orally their argument as to why they're right and respond to questions from the justices. And then after that oral argument, the Supreme Court will issue a final ruling. So thanks so much for listening. If you have any questions, please post them in our comments section. Please subscribe to us on YouTube and iTunes, and feel free to call us for an initial consultation, 630-324-6666. Thanks.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.